Hello, friends. Welcome to An Academy. This is me, Dr. Sidharth Arora. So, friends, you might have read in the news, and I hope you haven't missed this part of the news, that there are recommendations in the Ministry of Law that we might be having regional Supreme Courts. You heard it right. So, it might be a possibility in the future if these recommendations turn out to be or is fructified into a law or policy that very soon we might have more than one Supreme Court. Apart from the Supreme Court at New Delhi, there might be other Supreme Courts, which was initially way back in 2014-15. We were hearing about things like National Court of Appeal, and who would have guessed that suddenly after 10 years this news has again erupted, and in all its honesty, yes, all its discussion about should we not have National Court of Appeals. Today we are facing a news, or we are reading a news, that the Ministry of Law might be considering this on a very serious note. So do you want to know about what these regional Supreme Courts would be? Then don't miss a single word in this entire video. This is a short, crisp, sharp video. I will try and cover up all these topics, whether it is with relationship to prelims or mains, or for that matter, even for the interest of a general concerned citizen. Make sure that you don't miss a single word. Watch me till the end. So, for those amongst you who do not know me, I'm Dr. Sidharth Arora. I'm a practicing advocate in the Supreme Court of India, and I've been blessed to be a part on an academy platform with more than 30 crore watch minutes from my learners who are in thousands and hundreds of thousands. So 300 million watch minutes, more than 260,000 followers, and several thousand dedications. I teach polity, governance, and international relation and PSI optional on the Unacademy platform for UPSC Civil Service Examination. Said live. SIDLIVE is my referral code. Next time you want to join an academy platform, please utilize this code. You will get an immediate huge discount. Today's video. Today's video is related to this news, and this news says Law Ministry accepts recommendation of a parliamentary committee to establish regional branches of the Supreme Court. So this news came in Bar and Bench, right? So this is where I credit this part of the news. It says the committee has given a recommendation that yes, in the pursuit of, and I mark these words, in the pursuit of, and I quote, access to justice, we should have regional benches of the Supreme Court. First, I'll try and decipher for all of you each of the words that are given over here. So, first of all, the nodal ministry, the ministry that we are concerned about, is the Union Ministry of Law and Justice, hence the two words law ministry. Then the words are recommendation of the parliamentary committee. Now, this is a very interesting part of our understanding of the law. So, whenever the government is fixed or is not too sure about how and in what manner, to what extent should we bring about a policy or law, then it has all the options available to refer such a matter to the consideration of the parliamentary committee. Parliamentary committee, as the name suggests, will be made up of legislators, but that's not it. Parliamentary committee is the actual true blue working of the parliament. Now, this is something very interesting that all of you must appreciate. What does this mean? So, just pay close attention and try and hear me out on this part. So, what is parliament? Parliament consists of those members who are the ruling party members as well as those members who are the opposition members. Now, when you are working in an open parliament, at that time, it is very difficult to cross the alley and start supporting an opposing point of view. In other words, if I am a member of the ruling party, but I do not like the proposition of the ruling party, I do not have the liberty to say my heart out. I might be facing action under anti defection law and whatnot. And the same could be on the other side. It is possible that an opposition member would be very much on the same page with the ruling party, but he dare not say a word. This is where parliamentary committee comes into the picture. Parliamentary committee works in a non-partisan manner. I'm repeating the word. It works in a non-partisan manner. In the sense, here you can cut across party lines and speak your heart out. You can support the views, the policies, the laws, even of the so-called opposing camp, which in the truest sense of parliamentary functioning is a very effective functioning, a very effective method of actually making unbiased, uninterested policy and laws. Another very crucial element of parliamentary committee is that it necessarily is not limited to legislators, that is, the members of the parliament. You can also call for expert opinions, legal experts in this matter, or experts in any field for that matter. Their opinion can be sought, they'll be made to participate, and they can actually add to the quality of the law, the policy, the legislation, as the case may be. So, the true blue, correct spirit of parliamentary functioning is actually the parliamentary committee. So, I've taken 2 points which is directly related to your syllabus and connected to this news. So, the law ministry has accepted the recommendation of parliamentary committee. Now, this is the third word for now. It says recommendation. None of these recommendations are binding on the law ministry or for that matter the government. In the sense, you have to again keep a word. These are merely recommendations. Or whatever I'm telling you today, these are still at recommendation stage. Nothing has actually happened. I don't know will it happen, or if and when it happens, then this news may be read as a part of an historical concept. Today, nothing has happened. They've just accepted the recommendation. Let us see where it goes ahead and in what form. So, Law Ministry has accepted that we will have regional benches of the Supreme Court, and this is the earlier part. So, Parliamentary Committee has been chaired by Rajya Sabha MP Sushil Kumar Modi, and this is the 133rd report on judicial processes and their reforms. And the parliamentary committee has already tabled the report to the parliament. Let's see what the government takes the call. What kind of call does it take finally? So we'll get to that when we get to it. For the time being, this is the news. Now, before we understand what are the merits of this, okay, just make sure that you read the words of the parliamentary committee. And I quote, the committee feels that the demand for having a regional bench of the Supreme Court is about access to justice, which is a fundamental right under the Constitution. The regional benches may also be seen as a solution to overflowing caseload of the judiciary and to reduce the litigation cost to the common man. You would do yourself a world of good if you break down this observation into constituent parts. The first part here is access to justice. Do we need justice? Yes. Is it possible for us to live without justice? Certainly not. The Constitution promises us justice. Yes. The preamble itself says justice, social, economic, and political. Similarly, Article 38 of the Constitution says that there should be justice, social, economic, and political. Similarly, Article 39, capital A, which was added by the 42nd Constitutional Amendment Act 1976, said that there should be no way that a citizen loses out on justice just because of economic constraints or any other constraint. Justice is paramount. Justice is the most important element that we need. Everything else follows these words. Do we need justice? Yes. But does everyone get access to justice? That is something that's $1 million question. That's a question that we need to answer. We can answer these questions in a very, very different way. For example, try and understand this is a huge country. Article 130 of the Constitution says that the Supreme Court of India shall be at New Delhi and in such other place as the Chief Justice, with prior consultation of the President, may so decide. But ever since 1950, from the inauguration of the present Supreme Court till today, we've had only one Supreme Court, which is at New Delhi. Justice is, or is justice, I'm asking a question rather than answering a question. Is justice very difficult just because of the sheer distance between New Delhi and the north, east, west, south corners of India? Because what is the Supreme Court? The Supreme Court is the highest appellate court, the highest court of appeal. It is the apex court of India. If you go through the data of the Supreme Court, then you will suddenly realize that most of the matters, if not most, at least the majority, a large fraction of the matters, which finally land up in the Supreme Court in the form of an appeal, land up from the northern part of this country rather than the southern ends of this country. How? Is a question that can be very easily answered just based on geography. Yes. Does it mean that the Supreme Court may not be accessible to everyone in this country? This is the moot question that we have to ask ourselves. Also, another issue is there is one Supreme Court. One, I repeat, there is one Supreme Court which is the end, which is the apex of hundreds of trial courts, subordinate courts, and dozens of high courts. All the courts finally, all the matters from various courts across this country will land up in the Supreme Court in the form of an appeal. Do you realize that there is a very high chance of pendency, a huge backlog of courts, a huge backlog of cases may be seen in the Supreme Court. Maybe. I'm just asking a question. As a humble student of law, I'm merely asking a question. We are laying down the facts on the table. Let you decide. The Supreme Court, however, has been consistently rejecting the proposal for setting up of benches of the Supreme Court at a place outside Delhi. I repeat my proposition. We are merely debating. There is no the truth. The final truth will, of course, come after deliberation, discussion, debate in the parliament. It has to pass the judicial muster. It has to stand corrected. It has to be valid on the grounds of federalism. You have to notice, is it affecting any other part of the constitution or not? But I ask myself this question. Why is the Supreme Court rejecting the proposal for setting up the benches of the Supreme Court at a place outside Delhi? For that, you have to read the Constitution of India. So, Article 130 in the Constitution of India says the Supreme Court shall sit in New Delhi or in such other places as the Chief Justice of India may, with the prior approval of the President, from time to time appoint. Now, what am I trying to tell you? Number one, the question that we have to face, is it possible to establish a regional bench of the Supreme Court? The answer to that is a big, loud yes. Coming up from Article 130 of the Constitution of India, if the Chief Justice of India may so decide, then we can have such other place or other places. Of course, the Chief Justice of India requires the approval of the President. Then it is possible that we can have another Supreme Court bench. But is it Supreme Court sitting at Delhi or is it benches of the Supreme Court sitting? See, you will have to read every line. Look at Article 130 of the Constitution. So, Article 130 says Supreme Court shall sit in Delhi or in such other place or places as the Chief Justice of India may decide. What does this translate to? Does it translate to that the entire Supreme Court as it is standing today in New Delhi can be shifted to another place? Or does it mean that the Supreme Court can be broken down into regional pieces and there could be one main branch in New Delhi and then there are many other branches all around this country? This is not very clear from this constitution and will certainly be discussed and hotly debated in the Supreme Court. Does Article 130 allow you to break down the Supreme Court into regional benches, or does it mean that the Supreme Court itself will be shifted from or can be shifted from Delhi to any other place or places? This is not a simple question to answer. It just means a difference in perspective as to whether you want to have a regional bench or you don't want to have a regional bench. So we've been discussing about National Court of Appeal. This is what was being discussed around 2014, 2015. At that time, for some reason, which I do not know what could be the actual reason, suddenly this entire issue fizzled out and nobody discussed about National Court of Appeal. But suddenly it has come up, and the issue would now be hotly debated that do we need a National Court of Appeal? Let me see this on the practical basis of why do we need the National Court of Appeal. So let's first focus all our energies and try and understand that why do we need a National Court of Appeal, if at all. Let us look at this from a practical point of view, and then you will be able to understand. So hold your breath and let me show you the first element. So there is a line oft repeated, and that says justice delayed is justice denied. I hope everyone agrees to this. Just speedy justice. Speedy justice has been accepted as a fundamental right under Article 21 of the Constitution. In fact, there was a very famous public interest litigation called as the Hussain Ara Khatun case, wherein the Supreme Court also held that yes, right to speedy trial is a crucial element of Article 21, must be guaranteed under Article 21, that is the Constitution of India. But are we getting this? First of all, it is not possible considering the scene what is happening around. So this is the data, and I'm not claiming that this data is a very recent data. But even if you go to the very recent data, you will not see, in fact, things are worse rather than any better than this. So if you read through the screen, as I said, don't get too finicky about the numbers, but just look at the dimensions here. Look at the quantums here. Look at the total number of cases which are pending, whether it is in the Supreme Court, whether it is in the district courts, and look at the number of years it is taking for the cases to get resolved. 25 to 30 years are also, there are cases which are pending for 25 to 30 years. And what has happened now is that the Supreme Court itself is bogged down by around 70,000 pending cases. 70,000 pending cases against the strength of 34 maximum judges in the Supreme Court. Considering that most of these judges are, or most of the benches comprise of 2 judges, if not 3, then also we might not have more than 15 to 16 working benches at the maximum possible strength. And in that case, do you realize it becomes a mathematical nightmare for us to be able to resolve all these cases which are pending before the Supreme Court. So, in that vein, can we come back to this truism which says justice delayed is justice denied? With 70 odd thousand pending cases and with a total strength of judges as 34, alongside the fact that new cases are every day, new cases are turning up at the doors and knocking at the doors for justice. Do you realize that it is practically not possible for us to not get away from the fact that justice delayed is certainly going to be justice denied? We only have one Supreme Court. Because of this, and I'm rewinding my slides rather than going ahead with those, this answers our question, or this is what is the concern of the government, that we need the National Court of Appeals. What is the thought process? The thought process is, I mean, this is just on paper. One of the thought processes is that there shall be one Supreme Court. One Supreme Court shall be at New Delhi. This is the primary bench, so to say. This is the bench which is, or this is the court which will look at only constitutional matters. Any challenge to the constitutional amendments, any provisions of the constitution should be dealt by this Supreme Court which is at Tilak Marg in New Delhi. Alongside, there shall be 4 National Court of Appeals. This is merely at proposition stage. As I'm saying, I'm repeating it the nth number time. This is only recommendation. what will happen is there will be regional national court of appeals. There will be one in the north zone, one in the east, one in the west, one in the south. Which states would be catered by which national court of appeal is, of course, for the future to decide. But in that zone, it could be like this. Say you lose a case or you're not satisfied with a trial court or a subordinate court decision, you go to your state's high court in the form of an appeal. If you are not satisfied from this matter also, from this decision of the high court also, further you will go to the National Court of Appeal, NCA, of your region, as in the north, the south, the east, or the west. Your matters will not land up in the Supreme Court at New Delhi unless and until they deal with constitutional challenges. What are you going to achieve? The achievement that is possible, at least what is being spoken about, is that number one, the Supreme Court at New Delhi shall be declogged. Number two, the Supreme Court at New Delhi would be better able to give its strength, give its attention and time to constitutional matters. Probably this is what the founding fathers had always thought about when they actually conceived of a Supreme Court. Because if memory serves me right, the original Supreme Court was supposed to have 1 plus 7 judges. That is 8 was the maximum strength of the judges in the Supreme Court. Now, it will be very difficult for us to believe that the founding fathers of the Constitution would have conceived of a Supreme Court with merely 8 judges catering to all kinds of appeal from the entire country. I am sure that something else was weighing heavy on their mind, and probably they had thought that all the appeals should end up at the level of high courts of the state, and very few matters, the only matters which were dealing with the constitutional discussions, should be finally sent to the Supreme Court. But that was not to be. What we actually saw that all the kind of cases from all the subordinate courts and from all the high courts, left, right, and center, started knocking at the doors of the Supreme Court, and that is why we are seeing 70,000 odd pending cases today. This is one of the methods in which the National Court of Appeal would work. Number 3 was that this is going to finally give you speedy justice if it works, and that if is a very big if. If it works, then the National Court of Appeal may finally give you the kind of relief, may finally reduce the pendency and give you access to justice to all. Well, if wishes were horses, I don't know. Will it work or not? Number one, first obstacle to this. So there are many obstacles to these matters. It's not that simple. There are many obstacles to this. Yes, we love timely justice. Yes, Lord Bryce's remark is huge in this. There is no better test of excellence of a government than the efficiency of its judicial system. As opposed to that, the number of pendencies of matters in India actually reflects very poorly on our ideals of giving timely and speedy justice. But there are certain questions. And the question that comes to my mind right at the outset is, does National Court of Appeal affect the spirit of federalism? Maybe. Yes. Let us make a hypothesis of a National Court of Appeal of North, East, West, and South. My first practical question would be, which states would be a part of the North Zone, which will be the South, which will be the East, which will be the West. Number 2, how would you distribute the power between the High Courts and the National Court of Appeal? Who will have the primacy on this part? Don't you think the entire pyramidal system of the judicial system would be affected because of this? Number 3 on this part is, don't you think there might be a conflict of interest, or probably there might be conflicts between one state and the other who are in the same zone? Because every state would like to have National Court of appeal in their territory rather than anybody's territory. Please remember, disputes are not always between the union and the state. The disputes are very often between two or more than two states. Don't you think the entire concept, the entire spirit of federalism would be under a challenge, would be under a question mark just because of this? Also, union territories is another question. How would National Court of Appeal affect the union territories? Another important issue. What about an issue in which center and states will have a dispute? How about another question? Let's say there is a dispute between center, government, a state in another zone, and a state in another zone. How and who will decide that matter? These and many more questions need to be answered before we hurry up or we rush with any kind of urgency for any ideal towards National Court of Appeal. There are many questions that need to be answered before we finally venture out into creating anything close to National Court of Appeal. I hope you have enjoyed this. I'm not claiming anything. I do not know whether National Court of Appeals will come into the picture. I really do not know whether the government is going to finally go ahead with these plans or not. But let's see how the cookie crumbles. In the meanwhile, make sure that you want to study in a realistic way of cracking this exam. Please use the special code SEDLIVE and join us on Unacademy. In the words of Unacademy, let's crack it. Until next time, God bless, thank you, and Jai Hind.